Hello and welcome to the NZ US Council podcast. I'm Jordan Small, Executive Director here at the Council. Today's discussion is with Hayden Thorne. He's a Kiwi, an aspiring academic and historian currently undertaking his PhD focused on the United States Supreme Court and the role that legal representation plays in the outcome of significant decisions. So it's fantastic to be able to sit down with Hayden and talk everything about the Supreme Court. Its decision-making and traditions, the personalities on the court, and the critical role that the court plays in the US is something that has fascinated me for a number of years now. So I've been in search for someone to talk to about the court for a while, and just last week stumbled upon Hayden. Of course, we talk about the impact of the passing of Justice Ruth Bader Ginsburg, a liberal icon and powerful voice for women, minorities, and the disenfranchised. We look at whether her jurisprudence changed during her tenure, or just that the persona and profile grew. And we briefly consider the importance of conventions and customs concerning the nomination and confirmation of Supreme Court judges, and what might be lost when these are tossed aside because of the politics of either side. I was also really keen to talk about the recent series of decisions that came out in about June this year. Decisions on LGBTQ, employment rights, abortion, and immigration, where the Chief Justice of the court has played a critical swing role, often siding with the court's liberal justices to provide a majority. So we talk about these decisions, the composition of the court, and what it is that Chief Justice Roberts, a conservative, is possibly motivated by. It's a great conversation, it's timely, and I hope you enjoy it. But let's start with you. You're a Kiwi legal historian with an interest in the decisions of the US Supreme Court. How did this interest come about, and why did you decide to back it up with a master's and now a PhD focused on the Supreme Court?
Yeah, it's an interesting question that sometimes I find asking myself. It sort of came out of a combination of circumstances. I went to law school, obviously, did my law degree, but never particularly enjoyed it that much. And I did, at the same time, I was doing a BA, partly in history, and I found I enjoyed that much more. And so I sort of found myself at the end of my undergrad looking for something to do next. Didn't really want to go into practice law because it just didn't interest me. So I thought I'd have another crack at the history stuff, and I did an honours year in history and sort of found myself drawn to some American history with some really good mentoring from our American history professor up at Vic. And sort of partway through my honours, which was not legally focused at all, I started to encounter a few Supreme Court decisions and bits and pieces. And that kind of just really got me interested in the legal side of things, which was something that we'd never studied in New Zealand. We don't do a lot of American law because it's not really relevant to New Zealand's law. But it sort of got me interested in quite a different system. And so I think the comparative aspect of, having learned about New Zealand law and then seeing this very different sort of style of law in the US, particularly their constitutional law. So I decided to do a master's focused around some aspects of that. And that just sort of pulled me in deeper and deeper. And, here I am now, sort of 2 years into a PhD, which is very much focused on the US Supreme Court and their kind of decision-making processes.
Were there particular decisions or rulings that really hooked your interest?
I think so. Some of my PhD is focused on some of the big cases from the 1960s, particularly in the area of criminal kind of due process. So that, Miranda and those sorts of cases. And, I think the thing that really gets me with those cases is how significant they are and how significant of an impact they have kind of on society as a whole. And so, in New Zealand, we study legal decisions, and they are important, but they're nowhere near at the level of what some of the US Supreme Court decisions have. And, the influence that some of those decisions have is really transformative. And so that's kind of, I think, what got me hooked.
Yeah, there's that. So I did a master's as well in law at a US university, and the Supreme Court, it was just a pleasure reading Supreme Court decisions, and I enjoyed reading cases in a way I had never enjoyed it in my undergrad level study, where I was reading mainly New Zealand cases, and just that very in the New Zealand cases, very transactional, technical, whereas reading those Supreme Court decisions, there's just a whole lot of policy considerations. They're the big societal questions.
Yeah, they're not just interested in, interpreting statutes, but, kind of, I guess the way the Constitution is, as a really short kind of punchy document, I guess, requires interpretation, and that interpretation requires an understanding of society and what society needs and wants. Not that they always get it right, but it's really interesting to sort of see that convergence of, I guess, politics and policy with the law at that really high level.
Yeah, absolutely. Let's bring us forward to today and the current political battle to fill the Supreme Court seat of Justice Ruth Bader Ginsburg. We know where Justice Ginsburg ended up, a celebrated liberal icon and almost a celebrity figure, certainly in those later years. And I wonder whether that's how she was perceived right from the start, or did we see a evolution in Justice Ginsburg's decisions and rulings, perhaps as the composition of the Supreme Court changed around her?
It's a really interesting question. I think for me, the place to start is actually before she gets on the Supreme Court. And it's something that there's been a little bit of discussion about in the media and things, but I think may still be a little bit overlooked, is how important her pre-court career was to both to her legacy and just to the law in America in general. So prior to being on the Supreme Court, she was a really influential advocate for women's rights and gender equality, and arguably one of the most important legal advocates in America's history, working with the ACLU on their women's rights project. I think she argued 6 significant cases in the Supreme Court herself, and won 5 of them on the basis of gender equality. So I think it's a really important place to start, because it gives you a really good idea of what her values were and what she stood for. And so that question of gender equality is something that features all the way through her career before the Supreme Court, but also on the Supreme Court. And she was heavily involved in a lot of the Supreme Court's decisions, I think in the 90s, relating to gender equality, and she authored a couple of significant rulings there. So I don't necessarily think, obviously she changed, and people change. If you're on an institution for 25 years or whatever the case is, your views are going to change somewhat. But I think a lot of the change can be put down to sort of her public image rather than her actual jurisprudence. Late in her career, she picked up this kind of cult following amongst liberals, as this kind of icon. And I don't necessarily think that was the result of her changing her jurisprudence, but actually just, people's views of her changed. And part of that might be down to the composition of the court, being sort of in later years often in a minority viewpoint and writing some really strong dissenting arguments that sort of resonate particularly with the left. And that gets picked up on. But I don't necessarily think it's because her own views changed.
Did being the dissenting voice, did that give her a lot more freedom to write those more forceful decisions?
Yeah, I think often you see some of the court's best work in its history has come through dissenting opinions. And I think it definitely does come from a little bit more freedom, because when you write for the majority, you're writing for yourself, but also potentially 4, 5 or 6 of your colleagues. And so you have to work in arguments that they agree with, and you have to get them to sign off. So there's a lot of negotiation that goes on in the drafting of those opinions. When you write a dissent, sometimes you're writing for a couple of other colleagues, but sometimes you're also just writing for yourself, and you can be a little bit more aggressive, I think, and forceful in laying out your views in a dissent than you can in a majority decision. And so I think that definitely plays a part. I think also her seniority. So as the later years of her career, she became the sort of senior justice on that liberal bloc, the liberal side of the court, which gave her a little bit more power over, the message that came from that group of justices. And those 4 liberal justices on the court were quite cohesive in their approach. And you often see them joining each other's arguments. And because she became the senior member of that group, she sort of took the lead on a few issues, I think, and that might have made her a little bit more visible. But I don't think necessarily it's because her views changed.
Yeah. So the thing I wonder is whether we are likely to see a liberal in the fashion of Justice Ginsburg ever nominated again.
It's a really interesting question, and I think my answer to that is probably different today than it would have been a couple of weeks ago. Yeah. And partly I think the precedent that Trump and the Republican Party have set by pushing through this nomination and the types of people that they have nominated, they're very conservative jurists, is possibly going to push the Democrats to respond in kind if they get the opportunity. And I guess the thing to remember is that if, in the future the Democratic Party controls the presidency at the Senate at the same time, then they can push through a really liberal nomination in the same way that, the Republican Party is doing at the moment. And so I don't think there's any reason why we wouldn't see that. Obama, when he nominated Merrick Garland in 2016, was a fairly sort of middle-of-the-road appointment or attempted appointment. But part of that, I think, was dictated by political considerations, knowing that they didn't have control of the Senate at that time. So the only realistic chance they had of pushing a nomination through was finding someone who might sort of occupy a bit of a middle ground, which obviously didn't work out for them, but it was kind of their best shot. But if they control the Senate at the same time as the presidency, then there's no reason why they wouldn't go down that route, I don't think.
So I want to get your thoughts on a series of recent decisions of the Supreme Court and the role, in particular, the role that Chief Justice Roberts has played in those decisions. This last term has featured major rulings on abortion, religion, and immigration, and included a fair number of surprises. In nearly all of the major cases, Chief Justice Roberts was in control, aligning sometimes with his fellow conservatives and at other times with the court's 4 liberals. Can you take us through the significance of those decisions, firstly, and then let's focus in on the role of the Chief Justice and what's going on there? What's his calculation? So let's start with, maybe the 3 or 4 key decisions from that period.
Cool. Okay. So I'll start, I guess, with the kind of big abortion decision. So there's 3 cases that I can point to from June of this year. So the Louisiana abortion case is the first and probably the most significant in terms of publicity. And I think it horribly offended a lot of conservatives who were not particularly pleased with Roberts' role in that case. So there, Roberts joined the 4 liberals on the court to uphold mostly the Roe v. Wade precedent, and, strike down some restrictions that Louisiana had placed on access to abortion. And I guess the really interesting thing is that it's almost exactly the same issue came up in a 2016 decision, where the composition of the court was slightly different, and Roberts dissented in that case and said that the court should have taken a different approach. And he changes his tune in the recent case based on the idea that that 2016 decision had set a precedent that he was bound to follow. So I think his respect for the institution of the court and his respect for the doctrine of precedent is really, really important to understanding his vote in that case. I think there's a whole lot of political considerations as well, but as the Chief Justice, he has a really strong respect for the institution of the court, and I think he's probably really wary of making too many radical changes by a 5-4 majority, and that it's probably better for the court's prestige if he kind of upholds some of these important decisions, even if they run possibly slightly counter to what he would actually like to do.
Yeah. So that's interesting. So he was in the dissenting minority in the 2016 decision.
Yeah.
And then in 2020, he follows the precedent of the majority.
Yeah, even though he'd dissented from the ruling. So it's a really complex case and a really complex issue to unpack. But I think, Roberts's role, it really outlines how important his role has been on the court, particularly in the last 18 months or so, but also going back a little bit further. One of the other significant cases was the LGBT employment rights decision, and there both Roberts and Gorsuch joined the Liberals in a 6-3 ruling, upholding provisions of the 1964 Civil Rights Act and applying them to discrimination on the basis of sexual orientation or gender identity. So effectively saying that, this older legislation, that came about during that civil rights movement also protects gender and sexual identity. And that was quite a controversial case for a lot of conservatives, although I think the public has probably accepted that one a little bit more. And again, Roberts's role is really crucial, although sort of notably Gorsuch joined that decision as well.
Yeah. And Gorsuch was a Trump
appointment, yeah. So I don't think Trump was particularly happy with that particular decision. He might have tweeted something about it. And then the third of those significant decisions was the immigration and the Deferred Action for Childhood Arrivals program, which, again, Roberts joined the 4 Liberals, but in a much more limited way. So that decision doesn't actually legitimise the DACA program, but is basically a rebuke of the way that the administration went about trying to stop that program. So it's very much a procedural decision. And so I think Roberts in that case, it was easier for him to join the Liberals because it was decided along procedural grounds rather than on matters of substantial sort of principle or anything like that. And so they basically said that the Department of Homeland Security had been arbitrary and capricious in making this decision. They hadn't considered all of the factors that they needed to consider, and basically hadn't followed proper processes. But it's still, a really significant decision in terms of how that act is used and how, that program is going to play out, especially if, the election results in a change in administration. That decision potentially will have protected that system for long enough that, it's no longer under threat, possibly.
Yeah. Could you talk to us a little bit more around the role of the Chief Justice in these decisions?
Yeah, so I think my impression of Roberts is that he's very much interested in the court's legacy and the court's kind of vitality as an institution, and making sure that there's to some degree public confidence in the court. And I don't think he wants to see a whole lot of kind of overturning of important precedents by very narrow majorities where those rulings might go against sort of a substantial amount of public opinion. I also think he's, and this is something that a lot of conservative justices have as part of their ideology, is they're very wary of overruling precedent, and they have a lot of respect for the court's previous decisions, even where they disagree with them. And it's a feature that you see sort of right throughout the court's history. But I think Roberts in particular is very mindful of the court's place in the American system and its proper role and function. And some of these questions he probably would hope that the legislature would deal with rather than the court, because they do become very political.
So is part of what's going on here that separate roles of Congress versus the courts, and someone in the tradition of Chief Justice Roberts is very much we interpret the law that the Constitution or the law as it is, and we try to avoid getting into the policy role, which is the role of Congress.
Yeah, very much so. I think it was Roberts who said at one of his confirmation hearings that his job on the court was to call balls and strikes. Not to make substantial political policy decisions. And so some of that, I think, is that, those are questions better left for the legislature. I also think he is still a conservative, and those rulings from this year shouldn't sort of disguise the fact that he is very much in that conservative mold. But I think he's also open to being collaborative, to listening to reasoned arguments, and to working with different groups of people. Most accounts suggest that the rest of the court has an immense amount of respect for him and the role he plays. And he's has been in a really interesting position up till now where, it's quite rare that the Chief Justice is also the swing justice. So he has a little bit of, although on the court you've got 9 justices, the Chief Justice is one of them, they all have an equal vote. The Chief Justice has some sort of procedural powers that give him a little bit more influence over the court's direction. And when you couple that with him being the swing justice, it's, they call it the Roberts Court. It very much is the Roberts Court, or has been the Roberts Court, because of those kind of dual roles as the swing justice and the Chief Justice.
Yeah.
So he's definitely, very much stamped his mark on the court and taken a very considered approach, I think, to, he has made some decisions that a lot of Liberals would disagree with, but also has sided with those Liberal justices where he feels it's necessary, and sort of shown that he's willing to listen and, take a contrary viewpoint to what his Conservative colleagues might.
Yeah. So that consideration of protecting the integrity of the institution, and I guess staying in line with public opinion or society. It seems like that's a very political position to be in. How does someone in his role, how does he manage that?
I think very carefully. It's a very challenging role to navigate. The Supreme Court as an institution has quite a long history of being quite majoritarian in the decision that it makes. It tends to, most of the time, follow where public opinion goes. And part of that, I think, is a perception thing, because if the court strays too far from kind of a majority opinion viewpoint, they sort of become very open to accusations of bias and being out of step, particularly given that they're not elected. They're there for life terms. There's kind of no recourse once they do make a decision. So I think they're very wary of, their place in the system. And, their place in the system isn't perfectly set in stone. It could change if they get too far out of line, theoretically. So I think, some of the justices in the court's recent history have obviously been more concerned with that than others. Some of them are just there to make, the decision that they feel is correct, and, damn the rest of the considerations. But I think Roberts in particular is very concerned with the court's kind of image, which I don't think is a bad thing at all.
Yeah. So the place I want to finish off here is to look again at the politics in the nomination and confirmation process. But I guess because you're a historian, what I'm interested in is your perspective as a historian who focuses on the decisions of the Supreme Court and the traditions of the court. So I just have a series of very short questions.
Yep.
We could just get a very punchy answer. Is what is being called hypocrisy just politics? And the nomination of a Supreme Court judge is a political process where you need the control of the Senate. So is there any significance in the decision of the Republicans to not follow their principle of not confirming a justice in the final year of a presidential term?
Yeah, that's a really fascinating sort of political question. The decision not to confirm Merrick Garland in 2016 is ultimately a political decision. And there's no sort of written rule that says they have to follow it. And so, from a purely legal perspective, I guess they are free to do as they choose. I guess where I would be weary of looking at it solely from that perspective is that, the Constitution is not just this single written document that has every piece of law that you need to know. A lot of, constitutional things operate by convention, unwritten rules and practices that become accepted over time. And so I think there's a real danger in sort of saying it's okay to, flip-flop around on those sorts of things. Whether that's something they need to address through legislation or through, the Senate rules or something like that, I'm not sure what the solution is. But while it is a political decision and you can understand exactly why they're doing it, it just feels a little bit iffy as well.
Yeah. That's the answer I wanted, which was there are, like you say, a range of conventions and just ways of doing things that oil or grease the wheels of decision making within any kind of political institution, and you need them there. I mean, the question I put to you is, let's say next time, sometime in the future, you have that split between in the future, say it's 2 years out from an election. I mean, is there anything to prevent a Senate, in that case, not accepting the nomination or not, taking the confirmation hearings?
Yeah, I mean, theoretically, they could do exactly that, right? And so there becomes a real danger that the process becomes so politicized that the Supreme Court kind of loses its credibility as an institution. And I think I would make the same argument in terms of there's been suggestions from the left that, they could change the number of justices on the court if they win the presidential election and stick 2 more justices on to kind of claw back a majority approach. And I would, I guess, give the same answer to that, is that, by convention, that's not how it's done. And those conventions are important. Yeah. And once you start mucking around with them, if the Democrats were to seat 2 more justices, what's to stop the Republicans doing the same thing 4 years later? And you end up with a court of 15.
Yeah.
So I think politicians need to be really careful to respect how the court operates. And, I don't like how political the nomination process has become. I think it's a real drawback, and it leads to kind of a lot of unnecessary conflict, and also potentially leads to not having the best people on the court. And some really good justices have missed out on appointments who would have done a really good job because of that political process.
Yeah. I recently watched a panel discussion where, maybe it was an interview, Justice Ginsburg talking, I guess she was talking about her career, and she says during that discussion, in these rough words, presidents have been disappointed with their nominations in the past. What's she talking about there?
So I guess the best way to illustrate that is by an example. So the 2 justices that I talked about earlier from the 50s, Chief Justice Warren and Justice Brennan, were both appointed by a Republican president who later allegedly described them as the 2 biggest mistakes he made during his presidency. Warren in particular was a Republican. He had been a governor of California, reasonably strong on law and order, came reasonably close to the Republican nomination to run for president as well. So he very much in that Republican Party mold. Once he gets on the court with a life appointment and not beholden to anyone, you very quickly see his kind of personal views start to come through, rather than him just taking politically correct positions to win votes. So there's kind of quite a long history on the court of, because they're so independent, the justices, it's really hard to predict their behaviour before they get on the court. Obviously, you have a body of work, but when they come from political backgrounds, when you're in politics, you have to play to your voters, right? You have to take positions that you think will win you votes. When you're on the Supreme Court, you don't have to do that. And so there's definitely plenty of justices who've disappointed the presidents who've nominated them. Even Gorsuch on the current court has, in a couple of cases, gone in a very different direction to what people would have expected from his pre-court career.
Interesting. Should any weighting be given to the reported wishes of Justice Ginsburg for a replacement to be decided after the election?
I think there's two answers to that question. The legal answer is no. It has no legal weight, no legal standing, and doesn't really mean anything. But in a political sense, I guess it has some importance as it's almost like a rallying cry for Democratic voters to, challenge the process that's going on at the moment. And, it gives you some idea of what the court themselves might think about the process. But in terms of, a purely legal perspective, it has no relevance to the process.
Yeah. And then finally, any quick thoughts on the nomination of Judge Amy Coney Barrett?
Yeah, I mean, from a personal perspective, I don't like the direction that might send the court in. I think she's very conservative, and her appointment potentially threatens the Roe v. Wade ruling, but also the court's upholding of the Affordable Care Act, so Obama's kind of signature healthcare plan. So there's a few areas where, there's potential problems. But the real issue for me, I think, from a sort of a neutral perspective, is that I think the Supreme Court works best when it is balanced. And so we've seen that this year with that kind of Roberts as the swing justice, and happy to kind of adopt a slightly more liberal position in some cases. And so when you've got sort of a 4-5 split or a 5-4 split, it means that whichever side's on the minority are always a chance to bring one justice around to their viewpoint. And you see the court make a lot more balanced decisions based on that. When you've got a 6-3 kind of conservative liberal split, it makes it much harder to actually get anything done if you're in that liberal group. And so it can lead to kind of I guess a bulldozing through of just conservative positions or liberal positions if the shoe was on the other foot, I think. Yeah. And I guess the other thing that I would make is that the court's role in society, part of the court's role is to protect minority groups and minority interests, groups who don't necessarily have the ability to influence, Congress or the Senate because they're not large enough in size to, attract significant representation in those areas. So the Supreme Court kind of acts as a backstop to protect those minority interests, and the court's long history suggests that conservative justices have done a really bad job of protecting minority groups. And so I guess that sounds kind of like a political answer, but I think if you study quite carefully the court's rulings in the past, they have a really terrible track record of protecting minority interests, and a lot of that comes from periods where the court was dominated by conservatives, so that concerns me as well, from a kind of semi-scholarly, semi-personal viewpoint, I suppose.
Yeah. Could you see a second justice jumping up to be a swing, like Gorsuch?
It could happen. It definitely could happen.
Because surely there must be others who, like Chief Justice Roberts, are concerned about the integrity of the institution. And
yeah, I definitely think there are options. I mean, there are some justices who are probably never going to do that. You look at a Clarence Thomas, you're kind of just stuck with what you get with him. But, Gorsuch has shown a willingness in some areas of the law to join the liberal side. And I think it's also worth remembering that the Supreme Court deals with a really broad range of issues. Yep. And so it's not, you can have a conservative justice who holds more liberal views in some areas than in others. Gorsuch has joined the Liberals in a number of cases dealing with the rights of American Indians, and that's given them a majority, I think, in 3 or 4 quite significant cases during his time on the court already. So there are different areas, I think, where those justices will be more likely to swing than others, but the real concern, I guess, is those kind of key areas like the Obamacare legislation and Roe v. Wade, which are certainly going to be topics of intense discussion in the next year or two.
That was Hayden Thorne, legal historian focused on the US Supreme Court. He's written a few really interesting, very accessible articles for New Zealand publication newsroom. I'll include links to those in the notes. That's another episode down. Don't forget to subscribe, Apple, Spotify, Google, wherever you listen to your podcasts, and send me an email with any questions or feedback on the episode or just more generally on the podcast. Thanks again. I'm Jordan Small. Join us next time for this NZ US Council Download.